You know, I keep seeing that background. I'm like, man, that thing's getting out of date. COVID's like old news at this point. But then I keep hearing out of New Zealand they're about to start lockdowns again. So the world's still a little crazy. But greetings, poopy heads. Welcome back to Disenthrall. I will be Patrick Smith. Today we have a cool chat for you about intellectual property and the difference between maybe legality, morality, and the aesthetics of sort of interpersonal behavior. Let's get into it. He has a plan, she has a plan, and you get to pay for it regardless.
The best way to get someone motivated is to stand for something strongly, deeply, passionately.
Subscribe to Disenthrall. Do as you're told.
Larken, did you know we were using your do as you're told on the show?
I had seen that before, but I forgot.
Well, ladies and gentlemen, I have with me two very special guests, Stephan Kinsella on my left and Larken Rose on my right, and I am in the juicy middle where I've always wanted to be. Welcome to the show, guys. How are you?
Very good.
Thanks for having me.
Cool. Okay, so how this all started is Larken beat me to creating a video about intellectual property and the difference between saying something is or should be illegal or immoral and something that you can attack people over versus something where you can just have a negative, personal opinion over it. And I don't want to poison this well too much, so Larken, why don't I hand it to you first? Larken, give us the summary of your video, and then we'll go straight to Kinsella, who had some critiques of it on Twitter today, which is why we brought everybody together here.
Okay, and it was a pretty short and simple video, and I'll see if I can make it even shorter and simpler. Basically, the gist of it is, to begin with, I don't really believe in intellectual property, because property, like ownership of something, means the exclusive right to decide what is done with something. If I own my car, I and I alone have the right to decide what's done with that. Until I trade it to somebody else. So if somebody else comes to take my car and says, "Hi, I'm taking your car," without your permission, I have the right to use force to stop them. And if they take it, I have the right to use force to get it back. So that's what actual ownership is. And I don't consider ideas or impressions or information or sort of conceptual stuff that isn't physical to be property. I don't believe in intellectual property. And my opponent today has actually written a good book explaining why intellectual property isn't a thing. And I agree with a lot of that. The point I made in the video is that there's a big range in between you shouldn't use violence against something and don't be a butthead. And it seems that there are a lot of voluntarists who sort of fall into the trap of thinking that all human behavior is digital. Either it's a violation of the non-aggression principle, or it's perfectly fine and everybody should do it and there's never a reason not to. And it's sort of a flip side of the there ought to be a law mentality that statists have, where, well, if something's bad, of course government should have a SWAT team to barge into anybody's house who's doing that supposedly bad thing, even if it isn't hurting anybody. And the flip side is, well, if it doesn't justify a violent response, then it must be perfectly okay. And I think there are a lot of occasions where people are sort of freeloading off of content created by other people, when those other people obviously intended to sell it and try to make money off of it. And while I do not believe that justifies a violent response against somebody who pirates my book, I don't even like the word pirate, because pirate implies stealing, so I put it in quotes. Everybody knows what the term means, but I don't actually consider it real stealing. But if somebody copies my book without my permission, or copies Candles in the Dark without my permission, as both of those have happened, I would never justify the use of violence against somebody for doing that. But I would still call them a poopy head, which is a technical philosophical term you might not be familiar with. Basically, I think it's less than ideal behavior to make it so that people creating content basically have to put in all the time and effort and those who benefit from it and like it and support it don't bother doing anything in return. So, I mean, Poopyhead isn't a very very high threshold, nowhere near violence. I think it's worth criticizing people who are apparently so unaware that the content that they like and support often only exists because one person or one little group of people put in all the time and effort to make it happen. And the attitude that, well, if it exists, I'm entitled to it, is kind of commie think, more than actually like individualists think of like, well, I appreciate what you did, so maybe I'll chip in a few bucks. Again, doesn't rise to the level of violence, but it's still the mentality that people are entitled to something because it exists, which seems to be behind a lot of people who think that's perfectly fine. I just kind of find it yucky, which is another technical philosophical term. So that's about it.
Let me flavor that before I give it to you, Stephan, if that's all right. Because 2-on-1 makes it a fair fight for you. So I tend to agree with this distinction that Larken is pointing out, where you have sort of legal, which is one judgment. You have moral, which is based on moral philosophy and something that I'm very concerned with. And I think both of those can have objective answers. You work through the equation, you get a true or false when you ask, is it okay to use force to prevent this activity from happening? That would be a legal question or a moral question. And then I think you also have an aesthetic sort of interpersonal shaming or ostracization sort of section, which is like, look, you can hold that, I don't know, furries are weird and you don't want to be friends with them and you don't want to associate with them. You won't sell to them or do business with them, and you'll ostracize them over behavior that you don't like, that doesn't rise to the level of a moral infraction that you could use force to prevent somebody from doing. And just to put in my context behind this, several times recently, I see Larken's content that we help put out, the Attend Candles website, for example. Shortly after we put in the work to not only record that, to edit it, to create the website, and to put it out there, even though we have an agreement on the purchase page that says, if by purchasing this and agreeing to access it, you agree to not download it and to not share it outside. So we made an overt agreement that was broken by somebody, which is going to happen with all intellectual property, because again, I'm with you on intellectual property not only being not a thing, but being an abomination that comes with a lot of harm, especially in the hands of the government. But it's also really shitty behavior, because people like Larken need money to be able to go and create more content. And when people don't contribute, then our ideas are amplified less. And I find that personally, subjectively, aesthetically distasteful. Not morally, not immoral, not illegal, can't use force on you over it, but I find that really shitty behavior, and to the point where I would probably want to associate with a person that did that less. And there's many examples of that. I'm just using Larken's Attend Candles as one. So, okay. 2-on-1 to you, Stephan.
Okay, well, of course, I think basically, I don't know any, I think it's a little bit of a straw man to point this out. I don't know any libertarians who think that everything that's legal is moral. I mean, almost every libertarian I know knows that rights are only a subset of morals, in a sense, and that just because something is legal and you have a right to do it doesn't mean that it's moral. I think everyone knows that, and I agree with that. And I agree that there could be ostracism and other measures for things that are immoral that don't rise to the level of a rights violation. My only disagreement was on the blanket statement that basically piracy is shitty or immoral or poophead or whatever, because it's now in certain contexts it can be. Like in your case, if you have a request or even a contract or a condition on a website and you say, look, I'm going to let you access this. I don't know if you have to pay or whether it's free or not. But anyway, if someone uses it on the condition that they don't copy it, download it, and they do that, I would agree that's shitty, because they're breaking a promise, basically, or they're being dishonest. But that's not because they copied something. It's because they broke a promise. Likewise, if I were to take something Larken did or someone else and I put my name on it, I'm being dishonest, and dishonesty is also immoral, and people can rightly criticize that. But merely downloading a copy of the HBO of an HBO documentary is not dishonest. It's not plagiarism, and it's not breaking a contract, because you're just getting a pirated copy. Someone else might have broken a contract to put the information up publicly. So I just don't think there's, like, if you want to say so, it's immoral to copy information, you have to give a reason. And the only reason I seem to hear is, well, because the business model of certain people depends upon you not doing that. It's like, well, your failed business model is not my fucking problem, you know? If you're going to have a business model that depends upon people not being able to copy something that's easily copyable, then it's a stupid business model, and it's just not going to work. So you have to take other measures or whatever. And I think there's... I would even agree that you could argue that there is a moral obligation to try to be generous and charitable and support these causes and these activists who are doing good work. You could say, if you have the means to support someone who needs the work and they're putting a lot of time and effort into it, you should chip in and donate. I even agree with that. But that's charity, and that's voluntary, and it's optional, and it's subjective. And there's no objective amount you can say, well, Kinsella should give $10 and Elon Musk should give $1 million or whatever. There's no fixed answer to that. It's just you should try to be generous and support these causes. But paying HBO subscription price just to support a market for there being a copyright dependent industry, just so there'll be someone maybe sell their documentary to someday, is just a ridiculous argument. And plus they aren't getting anything from the money I pay to HBO. It'd be better for me to send them $1 than to give $20 to HBO, I'm sure. Right? So if you want to argue that the documentary makers need some support and contributions, I'd be all in favor of that. So my point is, there's nothing wrong with copy. If someone makes information public, then no one who copies it is doing anything wrong. They're not being dishonest. They're not breaking a contract. They're not being shitty. So that's my only point.
Yeah, it's the nothing wrong with part that I think is completely false. Like with Candles in the Dark, we totally had an agreement, and somebody broke it, and we don't know who, and we're not going to bother trying to find out, because like it's out there, and that's going to happen. As for the crappy business model, it's a little bit like saying, well, you live in a neighborhood where people steal cars, so if you live in a neighborhood where it's easy for people to do something, it's your fault, and that's really weird and creepy.
Copying is not stealing.
Yeah, it's not stealing, but the fact that somebody has an easy opportunity to do something butt-headed doesn't make it not butt-headed, and it doesn't make it the fault.
But what makes it butt-headed? What's wrong with copying information that's public? What's wrong with it?
So when it comes to my book, for example, there's no written agreement that if you buy my book, you're not allowed to copy it. Like, how would I even make such an agreement? But there's still obviously an implied thing with that and a million other things that people try to sell, that this is one of the things I'm not trying to give away free. And I put in a bunch of time and effort, and I want people to pay for it. And that is obviously my mission. And for somebody else to benefit from that, knowing full well that that was my intention, is basically saying, I don't care about the time and effort you put into it. I feel entitled to what you had if I agree with it. And that starts to get into what I think is commie thing. Now, some people, and I'm not saying you're on this side, but I've actually asked some people, if I like made a movie or something and I said, I'm going to try really hard to make it impossible to copy this without my permission. So we're only going to show it in like a sealed room, and you can't come in to watch it if you don't go through a metal detector. So there's no way to record it and stuff and all that silliness. Would that be justified? And some people, I assume you wouldn't be in this camp, but some people go, well, yeah, if you made it, why should I not be entitled to it?
No, I agree with you on this one. I agree with you on that one. Yeah.
Okay.
But that's another special case, because you have a deal. You have a deal with the owner, and plus it's a term of entry into the theater. So all these special cases, I agree with you on.
Right. Now, between that and I released something that I tried to pay for. I mean, that I tried to have people pay for. They didn't formally agree to it, but obviously there was the implication that I want people to pay for this to get it. And if people try to get it without paying for it, obviously they're going against what I actually want to have happen with my stuff. And that's true whether they're the one, sneaking in to pirate something, or they're just like downloading it after somebody else posted it somewhere. And so to say there's nothing wrong with that, like imagine somebody made the most awesome movie you've ever seen. And, obviously this is an extreme hypothetical. And a whole bunch of people thought, that's so great. None of us are going to pay for it. We're all going to torrent it. And it's basically saying that the person who put in all the time and effort and all the expense and everything into it has some obligation to be the only one who gives anything for that thing to exist and be out there. Like I see a bunch of people saying, well, what's important is spreading the word, not making money off of it. And oddly, the people who say that almost never actually create anything, because it implies, and again, this sort of mirrors the commie mentality. It implies that those of us able to make something have an obligation to do it for free, and that everybody else should be able to pirate it and copy it and send it around against our wishes just because it exists. And that sort of boils down to an entitlement mentality. And there's a contradiction if you think that, like, well, if there was a way for me to make it physically impossible for somebody to copy it, that's perfectly fine. But if somebody sneakily finds a way around that to copy it without my blessing and without my consent, that's perfectly fine too. I don't know how you can
listen, but it's not sneaky. See, suppose there's no copyright law, then there's going to be pirated sites all over. They're not even going to be hidden, right? So this anarchist show would be on many websites right now. Okay, and so if I download it, I'm not being sneaky. I'm just downloading a file. What's sneaky about that?
Let me tease apart a definitional difference that I see that we're all having here, and I think it's around the usage of the word moral. I think Stephan is using the word immoral, differently than we are. When I say something is immoral, that means that I can use force to stop it justifiably. So
no, I just mean unethical, shitty, wrong. That's all I mean.
Right. That's the break in our conversation. I'm pointing this out. This is the break in our conversation. When you say that something is moral, you're using that word differently than we are. Like, when we're just saying it's like my personal opinion that is shitty behavior that carries no weight.
I'm disagreeing with that. I'm disagreeing with your opinion. I think my opinion is that it's not shitty to copy public information. Ever.
Here's a simple scenario, because I mean, there's a million, hypotheticals we could come up with, and I won't bother going through all of them. Suppose somebody spends $20 million to build a big drive-in theater, and they put a big 10-foot fence around it, and they charge like a few bucks for people to go in and watch a movie, and on awesome sound system and on a huge screen, and it's really cool and everything. And obviously their goal is to get back their expenses and make money off of providing this service for people. And they even build a big fence around it so people can't just see over it. And one of the people who lives nearby sets up a 20-foot scaffolding so they can climb up it and sit there with their binoculars and watch all the movies they want for free. Do you not see something kind of rude and obnoxious about the neighborhood?
Zero, not at all. In fact, in reality, this is what happened. You had these drive-in movie theaters and people were free riding. And so the owners came up with means of exclusion, which is they started installing these little speakers next to each car so that you couldn't sit on a hilltop nearby and watch it for free. So the owners had to make a business decision and say, our business model is something that is easy for people to free ride off of, and we might not get as many customers, paying customers, as we otherwise would. So to determine whether this business model is viable, we have to see if there's a way we can exclude enough customers unless they pay so that we can make a profit. And they did that with these little drive-in speakers. And so this is just the way the free market works. No, I don't think there's anything wrong with looking at visible information that people make public. If you make information public, then you really have zero complaint that other people can access it.
But there's no such thing as making it public. And the thing is...
Yes, there is. It's called publishing.
The ease with which somebody can do something doesn't determine whether it's butt-headed. Like, yeah, it's really damn hard to produce content that won't immediately be, copied without your consent and spread all over the place. Like the fact that it's easy and a challenge to make that not happen and you have to like deal with it, that's not a determining factor. Like, well, if it's easy to do something, it must be perfectly okay. Like that's a really weird argument.
I think it's okay because you haven't shown what's wrong with me copying public information. Now, again, if I buy your book with the understanding that I'm not going to do that and I do it, I agree that's criticizable. Okay, that's wrong. It's shitty.
Well, you're calling it public information when it's not trying to be public information. It's trying to be like from the people who made it. It's trying to be information available to the people who pay for it. And then it just
once it's on the internet, it's public, right? All I'm saying is once it's on the internet, it's public. It's no longer secret and proprietary. It's no longer behind a wall. If it's on the internet, it's public.
Well, that's sort of like saying, well, you parked your car on the street. That's public. It's mine now. Like,
no, it's not, because we agree that there's property rights in cars. And if you're against intellectual property, then you don't agree there's property right in information. So I think the reasoning you're giving is it's like you almost want to be for IP, but you're too much of an anarchist to be in favor of the laws. But you're parroting the IP logic in a lot of what you're saying.
Yeah, no. It's not the same to degree. Yeah, stealing a card would justify force, and copying a book or whatever doesn't. But it's still the argument that, well, it was really easy to get it as the basis for you took something that somebody else made that they only wanted that.
You're not taking it. You're not taking. You're copying it.
Yeah,
I don't know. From it. I don't know if I have the same argument as Larken, so Larken can tell me if I'm not attempting to represent him. I'll represent myself here, and it may be different from him. So for me, the problem has nothing to do with intellectual property. It has nothing to do with the digital content involved. It is a aesthetic behavior that someone is taking actions that make an activist for liberty less efficacious. And that could be anything. Like if somebody goes around and talks shit about Larken baselessly, I would find that as shitty behavior as distributing Larken's content for free that he's trying to monetize so that he can pay his bills so that he can make more liberty content. It has nothing to do with intellectual property for me. I have no belief in any conception of rightful intellectual property. It is just the anti-liberty activist behavior that is where my criticism comes from. Larken, is that what you're saying too, or am I separate from you?
I think that's sort of just a different way to describe pretty much the same dang thing. Because it isn't like I own the words in this book and I'm going to beat up anybody who takes it. It's basically has to do with the creation and the benefit to other people who know damn well that the people who created it weren't intending for other people to benefit unless they paid. And they're just like, well, screw you. We don't care. It's easy for us to take it without your consent, without your blessing, even though it's not what you wanted. And while that doesn't rise to a violation of the non-aggression principle, I just think it's sort of buttheaded. And I think the guy who builds a scaffolding tower to watch a bunch of free movies is also kind of being a little bit of a butthead, even though he's still on his property, even though it's not a violation of the non-aggression principle, even though, hey, I'm just looking at the air. I'm just looking at the air 20 feet higher because I built scaffolding. It's still just the intent to benefit from something that you know damn well the other person created, hoping to get paid for it. It's just, to me, this is like, I just don't see a distinction between different types of information. You know, Jeff Tucker talks about when he's criticizing IP, like the complaints about IP, which is similar to some of your complaints, I believe. It's like a little girl that has a new hairstyle and she goes to school and the next day all the girls have the same haircut and she starts whining that they stole her haircut. I mean, this is just bullshit. Yeah, and I agree.
I mean, honestly, I could make the argument the other way almost. I think if you're an activist for liberty, like we are, now, not if you're doing things for profit, okay, like documentaries and things you really want to make a profit off of. But if you're just trying to spread the word like we are, I would argue paywalling your book and not putting it online for free is an asshole move. Because your goal is not to make a couple of extra bucks on your book. Because let's face it, our books are not making a lot of. Our books are not like making. If you're making a lot of money, that's one thing. Although I personally don't even think you're going to make less money if you put a free copy online. But I could argue you're being a jerk by not putting your books online for free.
You know how I said you didn't have the commie mentality? I take it back.
Oh, Kami's been called. Kami has been called.
Obligated because I made something from each according to his ability. I'm obligated to release that out into the world.
No, it's not because of that. It's because if your goal is activism and spreading the word, you want as many people to read your work as possible.
Yeah, but you talk as if I'm obligated to release it because I made it, because it exists. I should release it.
I'm simply
to
saying
the
you
world.
could make the argument the other way around.
That is the commie mentality.
All my stuff is CC0. Everything I write is CC0. I don't paywall anything, and I put it all online.
Okay, that's
hold on. Apples to apples. Everything Larken puts out is not copyright, enforced either, right? That's not what we're talking about.
I'm not saying copyright. I'm just saying I actually put it online. I try to make it easy for people to read it because I want to spread the word.
Yeah, and I do that with the vast majority of things I've done over the last 26 years. But there's a difference between it's nice to do that to get the word out, and you're a bad person if you don't give away for free the fruits of your labor.
Well, but you're arguing you're a bad person if you copy public information. So I mean, it's just an arbitrary.
Well, you're the one labeling it public information to make it sound like something it isn't.
Public has a meaning. I mean, if you publish a book, it's published. That's what the word means. It means it's accessible to the public. It means it's not secret. It's not. I don't have to commit trespass against your property to get it. It's information has a nature that it can be copied.
It's not property, but obviously, like of the few things I do that I sell, the intent was I want people to have this when they actually pay for it, and not when they don't, unless I'm just giving it away for free. And
I mean, so let's say I'm at home one night on a Friday night, and I hear about this anarchist documentary, and I don't have that HBO subscription, and I can just click on a button and I can play it on my screen for free. Who actually did I hurt by doing that, and how is that immoral to copy information that?
I don't think that's the claim.
I think it is.
That isn't even a claim. There isn't a harm and a damage that justifies force. There is, however, a loss when, like in this case, there's an extra step of complication because, HBO pays other people to make things like this. Like, Kim and Todd made this series over a period of years and they got paid to do it already. I don't even know if they get like a cut of sales in the future. I don't know what arrangement they have.
No, I'm asking what the loss is. You said there's a loss. What is the loss exactly?
That's the second part of the sentence. But their ability to get future projects funded by places like HBO is going to depend in large part on the profitability of projects they already did, like this one. If they make a huge thing and everybody pirates it, they're going to go, well, I mean,
you're missing my point. You're missing my point. What if I wouldn't have bought? What if my option is to either be an asshole and pirate it, or pay a fee, and I'm not going to pay the fee. So if I follow your strictures, I'm just not going to see it. So in either case, if I pirate it or if I don't buy the subscription and don't watch it, they don't get the money. But in the second case, I don't get to see it either. So how does it hurt them if I watch it when I wouldn't have paid them anyway? How does it hurt them?
Yeah, if you wouldn't have paid for it, it doesn't necessarily, but it's still you benefiting from something. I've actually told a bunch of people, and I say this on a regular basis, if something I made is for sale and the choice is between you're not going to afford it, so you're never going to see it like anyway, or you see it for free, I would rather the latter happen. And basically I'm giving my permission and blessing to, like, if you all the way couldn't pay for it anyway, I'd rather you see it.
What if there's a million people in Africa that can't afford this at all, but they could watch the anarchists by pirating it? Do you think that's okay?
Well, you're talking about okay, as if it's
is it shitty? Is it shitty in your terminology? For some poor African kid in Chad to download the movie and watch it, is that shitty?
A little bit, because if they knew it was trying to be a thing for sale, like what I just said about what I tell people, that's me telling it about my stuff. I can't tell people, well, you have my permission to watch HBO. Like I don't own HBO. For my stuff, I would tell people, like, if you aren't going to pay for it at all, I guess I'd rather you just get it for nothing rather than not get it. But I can't do that for anybody else. So to get something from somebody that damn well made it with the intent of selling it for a profit is a little bit butt-headed. Again, it's not a
Yeah,
capital
well, you keep asserting
offense.
you keep asserting it. To my mind, you haven't given any reasons to say that it's butt-headed. You just think that because you put, this labor theory of value, you put hard work into it, and you intend to get a profit off of it, and people aren't playing along because you haven't found a way to exclude them.
Value. It's that it exists as a result of somebody's effort who doesn't want it to go to people who didn't pay for it. And then it does anyway, because, on a practical term, when it's just zeros and ones, it's basically impossible to stop.
Right.
But that doesn't mean
it's a difficult business model. I agree.
A way for people to behave.
I don't think it's intended to be I want to give Larken the last word because I think he said he only had 30 minutes and we're right up against 30 minutes. So I'm happy to continue the discussion if you need to go. Larken, do you want to have the last word?
Well, yeah. That was basically it. And the thing is there's a lot of other ways in which it applies that I see people, and like I noticed you agreed with a bunch of things that I agree with, as far as like, if you have a contract, don't break it and share it. And if it's possible to limit who can see something, like that's acceptable. Well, except then you said I'd be a butthead if I did that. So that was a little confusing. Like, we may agree on a bunch of the hypotheticals that we came up with, but there's still just the underlying thing of if you support something and want it to keep happening, allowing one person or a small group of people to bear the entire burden of making that exist, and just going, well, I'm just going to take it and use it and forward it around and copy it and whatever. It's just sort of a little bit offensive. It's not very offensive.
So you say.
Yeah. And yeah, I was a little bit surprised that you think it's more butt-headed for somebody to not give away the fruits of their labor for free than it is for somebody
fruits of
else.
The labor. Here we go with this Marxist Lockean bullshit. This is the IP idea, man. You've got it. Fruits of their labor.
No,
there's no such thing as the fruits of your labor. That's a metaphor.
What a ridiculous thing to say. Of course there is. You put in lots of effort and make something, that's the fruits of your labor. Like,
we don't make things. We transform things.
Way to just make up
you're not a Randian, right?
Distinctions.
Look, I was just talking to Keith Knight. Keith Knight just published the Voluntarist Handbook, okay? And it's a nice collection of anarchist essays, voluntarist essays. And he released it online in a PDF. And I commended him for that, because he's not under this stupid delusion he's going to become a millionaire off the book, and he really wants to spread the ideas. I mean, if you put a paywall up around these things, then you're restricting it to the rich Westerners. There's lots of poor people in the world who can't access our ideas if we don't make it available to them.
Are they entitled to it?
Are
they entitled to somebody else's efforts?
No, but if you're working for liberty, you're not doing it to make money. You're doing it to spread the word of liberty.
But if he,
I admire libertarians who are trying to actually spread the ideas, right?
The other side of that, though, is like he'll be able to create more liberty content if he's able to pay his bills and not have to get a day job and not have. There's a difference between like trying to make it a for-profit business and trying to be self-sustaining enough to buy more bandwidth to make more content.
Yeah, let me end on this, because
but why did he do it? Why did he do it?
He can follow up as much as he wants. There's also this weird thing, and I've seen it in comments all over the place, including under my video, where people have this thing, well, this is so important that you shouldn't get paid for it, basically. Like, and I was like, well, if I mowed lawns and charged people money, you'd go, well, duh, that's fine. But if I do something way more important, I should do it for free? Where the hell is the logic of that? And by the way, for the last 26 years, the vast majority of what I've made has been available for free. Well, all of it's been available for free. Most of it with my blessing, some without. But this weird attitude that, well, this is so important that nobody should pay you for it. It's just...
No, that's not my argument. That's not my argument at all. No, I don't have that argument. That's the information wants to be free crowd or whatever. Yeah, I don't agree with that.
Okay. Well, I have to run, so you... You two can.
I think copying is an act of love, man. Copying is an act of love. Copy. Nothing wrong with it.
No, it's an act of buttheadedness if the creator didn't want it to be copied.
Larken, thanks for hopping on. I'm gonna continue the chat. Larken, I'll talk to you soon. I think we might be doing another Anarchast following the next episode of The Anarchist, right? We'll see how that goes.
Yeah, which is in 2 days. Yeah.
All right, man.
Go sign up to HBO instead of pirating it. All right.
Thanks,
See you
Larken.
both later. Have a good one.
All right, let me readjust the camera here. There we go. Okay, so I think I have a different argument. He was saying that people that were stretching their necks to watch a movie that they didn't pay for at the drive-in movie theater was bad. I really don't care about that because again, my problem has nothing to do with IP.
No, I know your argument actually makes more sense. Yeah,
it's just okay. Well, do you have any problems with my argument?
I think that I think you're trying to say that we have some kind of obligation to try to support people that put a lot of work into things that we value, okay, and try not to free ride so much. I just don't know if buying into their copyright business model is the way to do that. I mean, like I said, I could easily send a donation to these filmmakers right now. I'm sure they have a company and a PayPal page or a donate button or something like that. Give them money directly. I mean, there's nothing wrong with that. But I don't think there's a strong obligation to, because lots of people can't afford it, or they wouldn't have paid for it anyway. So what good does it do to the world if I intentionally refrain from watching it for free when I wouldn't have paid for it? I mean, it just, the whole thing makes no sense. And this whole thing about when the owner intended it to not be copied. Look, if it's mostly secret and it's behind a paywall and no one's leaked it yet, yeah, I would agree that if you're the guy that leaks it, you're shitty. Okay. But once it's out there, then that part of the business model has failed, and now it's publicly available.
Yeah, and to refine my position even more, I'm not talking about the people that view it without paying for it. I'm talking about the people that do the sharing, that undermine undermine the business model of the liberty activist. And business model I'm using very lightly because, like, we're not out here for profit. Disenthrall has not made any appreciable amount of money over the time it's been around. And yet, if somebody went out of their way to undermine the little money that it's able to make, I would say, man, that's kind of shitty. Can you not? Like, I give most of my stuff away. And if there's something I found that I want to, ask for money for, I find it shitty for people to share it. But the viewers, the people that consume it, I had no contract with them. I'm not going to get super offended if somebody watches. Like, if somebody in Africa that can't afford it, watches a pirated copy of I don't have any content that I have paywalled right now, for the record. But if I did,
if you do,
well,
yeah, if you did, I don't know what this candles thing you're talking about was, but if you took some time to produce something that had an activist cause, but you also need to try to have a business model to get some money from it to make it sustainable and all this, and you chose not to make it public, not to put it all in for free, but to try to keep it paywalled. If you chose to do that, I would respect your choice and try not to be the one to upload it to make it easier for everyone else to bust your business model. Yeah, so I would agree with you in that limited case. I wouldn't be the one to upload it.
And even then, I'm not claiming that we can attack the people that do the uploading or that do the distribution. I'm not saying that. I'm just my position is merely one of, hey, that's shitty behavior, don't do it. But and now here I'm going to call myself out as a hypocrite, because last Sunday we had a watch party on our Discord server where we streamed The Anarchist episode 1 for everybody that wanted to watch it. So technically, I made myself the distributor of that content. And I'm doing the very thing I'm fucking criticizing right now. Of
course. And I guarantee that Larken and everyone else, we all go to these, we find pirated content of books online when we're doing research and we can't find it another way. We violate these rules all the time because it's ridiculous. And intellectual property is a ridiculous thing, right? And we all sense that information is not an ownable thing, and you're really not hurting anyone when you download and copy information that you can access. As long as you're not breaking a contract or being dishonest when you do it. So my comment was narrowly restricted to the action of downloading already pirated, publicly available information. That was what I was referring to. I don't think that's dickish at all to do that.
I don't disagree with you. Yeah.
Now, I do think that if I'm getting, I donate money to several people whose podcasts. I think I throw you money every month. You do. I support people that I support people that I want to encourage, but it's the problem. The other problem is if it's not a market transaction, then there's no objective number you can come up with. It's all just touchy-feely stuff, right?
Sure.
In which case, if there's no objective number, then you can't criticize someone if their number's 0. I mean, there's really no number whatsoever.
So let's go to questions. There's been a lot of really weird comments, like just really strange stuff. So here's one. He says, I have a question for Kinsella. Is there any moral weight on an agreement with no associated penalty for removing consent? So this would be like a contract with no penalty clause.
Well, that's a complicated question because I actually don't. I buy into the. I believe in the Rothbard. Excuse me. Hold on a second. Sorry, got a mosquito in my throat or something. The right way to view contracts, I believe, is Rothbard's title transfer theory of contract. So contracts are not to be viewed as binding obligations or promises, but only as transfers of title. So if there's no penalty, that means there's no contract. Because a contract has to transfer title to something. So normally a contract would say, I promise not to do this, and if I do, then I owe you damages. That's how contracts are understood now. There's a binding promise, a breach of the contract, and then damages are owed. Under Rothbard's view and under my view, there's no such thing as breach of a contract. It's just it specifies a condition under which a title is transferred. So it would say, if you do this, then this much of your money transfers to me. So if the guy says there's no penalty, so all penalty clauses would be a title transfer. So if there's no penalty clause, then there's no contract.
Let's see. Paolo says, for Stephan, the donation model doesn't work. If you need to survive out of your content, is hard to let it go for free when you don't have money to pay for groceries. What will be a good solution for you? I think he's saying donation for Liberty stuff doesn't work. He's right. That's definitely not a valid, viable business model. So what's a good solution for Liberty activists?
The only thing I can think of is, get a job in a sector where part of your job is doing that, like you're paid to do that, or do what Francis Ford Coppola said. Like he said, maybe you work a job and then in the morning you write your screenplay. So you basically become your own benefactor. I mean, that's what I've done. I have a career. I've had a career, and I'm my own benefactor. I don't ask people for money because I know that's not a viable way. So I support myself. I don't know what else you can do. Maybe ask for charity from foundations. No, it's difficult to get paid to do something that you can't sell. I don't know the answer to it.
Okay, so I think we've at least come to an agreement on some things. I don't feel like I disagree with you, and I think you disagree with me on the fine point where I call a specific behavior shitty. So would you like to go and talk about your the plank that you got added to the, what is it, the LP Nevada? Is that something you're interested in going over? Sure.
If you think it's okay to do two things in one, that's okay with me.
Oh, my viewers are used to it.
Let's do it.
I thought this was a cool topic. Would you like me to read it, and then maybe we can talk through how it came to be and why, and the challenges behind formulating language like this? Or do you want to read it?
I wouldn't read the whole post. Let me just explain what happened, and maybe you can interject when you need to clarify something.
Cool.
So basically, I was at the Reno Libertarian Party convention in May when the Mises Caucus took over, and also got some changes made to the platform. And I was involved with that, and I was asked to help clarify or to write a plank on aggression and property rights, which did not exist in there. It was sort of like implied, like aggression was mentioned a couple times, but it was never defined. Property rights were never clearly defined. So I wrote one, and it was put in there. Now it's in 2.1, and I wrote it in a particular way with input from some other people on the Mises Caucus and some feedback, and went through several iterations. And if you want to read the actual language, you can read the language of 2.1. It's two fairly short paragraphs. You want to do that?
Yeah, and I think it's cool to do this because, like, everybody thinks it's really easy to define the terms that we use when we're talking about liberty until you say, okay, go do it. And then you find it's actually really complicated to make this lossy thought compression algorithm that is language spit out consistent principles. And I think he did a pretty good job here in codifying. 2.1 defines aggression, property, and contract. Aggression is the use, trespass against, or invasion of the borders of another person's owned resource, property, without the owner's consent, or the threat thereof. We oppose all acts of aggression as illegitimate and unjust, whether committed by private actors or the state. Each person is the presumptive owner of his or her body, self-ownership, which right may be forfeited only as a consequence of committing an act of aggression. Property rights in external scarce resources are determined in accordance with the principles of original appropriation or homesteading, whereby a person becomes an owner of an unowned resource by first use and transformation. Contract, whereby the owner consensually transfers ownership to another person, and rectification, which I think is the same thing as tort, right? I had never heard.
No, it's the same thing as restitution.
Oh, okay. Whereby an owner's property rights in certain resources are transferred to a victim of the owner's tort, trespass, or aggression to compensate the victim. Do you want to read the third paragraph?
No, the third was already there. I just added these ahead of that, so that the third just goes into some specific examples. But so most libertarians would say aggression is the initiation of force, right? Something like that. But that's not really a good definition because it's kind of awkward. First of all, that doesn't include threats, and it doesn't include fraud, at least on first glance. And it doesn't, like if I walk across someone's lawn at midnight when they're sleeping, did I really initiate force? You know, it's kind of odd. I think the best way to understand it is this. And the way I worded it like this was for these reasons. Well, the word aggression, like on its plain meaning, means like when you physically hit another person, like they're physically fighting, right? And if you say you're opposed to aggression, what you mean is you're opposed to like hitting other people. Mm-hmm. And that's just another way of saying each person owns their body, right? Because if it's impermissible for me to hit your body, that means that you're not consenting to it. And the only reason I need your consent is if you own your body. So it's another way of saying self-ownership or body rights. So that's why I put that in there first. So every person owns their body, but that right is not unlimited for the very reason that you can't use it to commit aggression. In other words, someone can't initiate force or aggress against me, but they can use force against me to repel me if I'm attacking them. So when I commit aggression, then I am forfeiting some of my rights in my body. I'm effectively giving you permission to hit my body back. Okay, so that's why I put that exception in there. But basically, self-ownership is the first property right. So aggression is the use of someone's property without their consent, and the property would be their body. And then the other things that we consider property are external resources that were at one time unowned, that came to be owned, and that are owned by someone now. So all legal disputes have to do with two or more people contesting the ownership, the right to control or use a given scarce resource, an external resource. And the way that we determine the owner is with homesteading, like who got it first, contract, like did you get it from a previous owner by contract, or was it transferred to you because someone hurt you, like they committed a tort against you. So that'd be rectification. So those three rules are the only ways that you can come to own property. You either the first one to get it, or you buy it from someone who had it, or they have to give it to you to pay you back for some damage they did to you. That's the only way to get ownership of something. And this way of putting it has several implications. Number one, it implies anarchy because the state violates these rules when it taxes us or outlaws competition, right, by monopolizing its services. It also implies intellectual property is not legitimate because intellectual property doesn't come about through any of these things here. In other words, intellectual property gives the owner of the copyright or the patent the right to stop you from using your property as you see fit, which violates your property rights. It also rules out voluntary slavery because the contract part only applies to external resources, not to your body. Your body, you can only lose rights in your body when you commit aggression. So that compact way of putting it has several implications, but I think it covers the whole field. And one thing we didn't list explicitly, I did list threats because the threat of force also counts as initiation of force or aggression, because it gives the person receiving the threat the right to respond, right? So if someone has a right to respond, then what they're responding to has to be aggression. But I didn't call out fraud specifically because fraud is implied. That is a prohibition against fraud, because the word consent is in there. The use of someone's resource that they own has to be with their consent. And fraud is a way of vitiating consent. You're deceiving someone about the nature of what's going on, and the consent that they give is not really informed consent or meaningful consent. So fraud is an application of that too.
The only I was about to say the only nitpick I have, but not even that. It's mainly a question, because you were the one that convinced me of first use as the only necessary homesteading action. Like, get there first and make first use of it. In here you say first use and transformation. So I just wanted to check and see if you meant something additional with the word transformation, or if that's kind of superfluous. Like, what if you just got there and used it first but didn't transform it in some way?
The transform sort of implies that you have to use it in a way that establishes some kind of publicly visible link between you and the resource. So that other people can see that there's property borders or property boundaries. There has to be a visible, Hoppe calls it intersubjectively ascertainable. We can just call it objective. There has to be an objective, provable link between you and the resource. So there has to be some stamp of your connection to it. If you just walk across it and leave, then no one even knows you were there. And if you claim it later, it's like a mere verbal declaration. So transform just means doing something with it that separates it out from other things, so people can tell that now this is owned. It basically means putting up a fence around it. It means establishing your ownership in a visible way. Transforming is one way of doing that. Go ahead. Sorry.
I was just going to say that I think the word transformation bothers me because it summons back in the mix that whole mix your labor with it, labor of theory of value. Your labor has something magical. You doing something to the property makes a difference. Whereas, the example I use when I'm talking about it is like a worm farm. You homestead a piece of property, or you wish to homestead a piece of property that has a bunch of worms underground. And if you disturb the ground in any way, if you modify or transform the property in any way, you might make the property less efficacious as a worm farm. So really, you're just going to say, hey, this is my property. I got here first and I'm using it as a worm farm. And then,
correct.
I guess if somebody challenged you,
go
ahead.
I would say but you need to somehow establish a publicly visible connection between you and the worm farm. Like maybe you put a fence around it, or something. You have to do something. The word transform is, I think of it as a if I was writing a treatise, I would give different examples and have footnotes and nuances. But the problem with the mixing your labor thing, I think Locke is in a way right, that when you mix your labor with an unknown resource, and all he meant by that was you transform it or you do something with it. You start using it basically in a certain way. The problem with his argument is that he assumes that the reason it works is because you own your labor. So it's kind of a mystical argument. And it leads to the IP idea, actually. You don't need to say you own your labor in order to say that mixing your labor with something is one way of homesteading it. In other words, mixing your labor with something is a way of embordering it. I mean, the general concept is what Hoppe writes about. It's called embordering. It's basically establishing a publicly visible link between yourself and the resource. And that depends upon the nature of the resource, too. Cows are homesteaded by branding them because they roam around. Land is transformed in a certain way. Other things are homesteaded by possession, like a stick or something like that.
So this is interesting. I've gone for years now without saying that you needed to separate it from nature. And I guess this is not the same thing you're talking about. Embordering, I think, is the perfect word, actually, to establish borders. Emborder, I like that. I'm gonna have to continue thinking about that. And I'd like to get your answer on the most common criticism I get when I talk about first use as the prime homesteading rule is what constitutes use? Because you could sit on the top of a hill in a lawn chair and be like, oh, I'm using all of this land with my eyes to enjoy the view, for example. Therefore, I've made first use of all of these vast tracts of land. Therefore, I have now homesteaded it all. What do you say to that?
Yeah, that's I think this is not like an a priori thing you can come up with from your armchair. This has to come from the kind of negotiation between people in reality. But you have to remember that anytime there's a dispute over a resource, then that dispute is over a particular type of use of the resource. So two people are when they have a conflict over a resource, it's going to be a conflict over a certain type of use, and that's going to depend upon the way the people want to use it and the nature of the resource itself. So the very nature of any dispute, like when two people come into court to argue who gets the thing, the very thing that they're fighting about helps to define the type of use appropriate for that thing that then would be the standard for who homesteaded or how was it homesteaded. So it's sort of a, now in particular cases you can give an answer, but I think that as a practical matter, yeah, you can't just observe something and claim it. You have to actually somehow border it. Now, let's say you put up a fence across, 1,000 square miles. You could claim that you've bordered it, but if you're not actually using the whole thing productively, then you're not going to be able to make enough income from that property to have resources to go around policing it all the time. So eventually people are going to start squatting on it, and they're going to gain ownership of it by acquisitive prescription or statute of limitations, which is another way of saying that I've effectively abandoned it. Like if someone squats on a corner of my property 100 miles away and I never tell them anything, and 100 years later they have a thriving town there, I've given up ownership of it. So unless I'm actually using this thing productively, it's impossible to homestead too much, because you're going to lose ownership of it at a certain time to squatters, basically.
There's so many different things happening here. So what was the thing you said right before abandonment? It was two words I'd never heard. You said if somebody is squatting on the land.
Acquisitive prescription?
Acquisitive prescription. Can you tell me what that means?
That's a civil law term. It's usually called statute of limitations in the common law. Acquisitive means to acquire. Prescription means the time limit has run out.
Okay. Now, I have previously held up until this moment, and I guess I'll defend that position, that there is no such thing as sort of like abandonment as long as the owner is alive, unless they take positive action to abandon something, like this sort of nascent or late. What's the word I'm looking for? This sort of like abandonment by default. I don't think it's a subjective thing that you can't really prove. Like if I have a watch and I put it down and I walk away, that's in no way really communicating definitely that I've abandoned that piece of property. I could have just wanted to leave it there and walk away for a month. What do you say about this abandonment stuff? Because it's a tricky issue.
So I guess I'm in between you and the mutualists, right? So the mutualists think that you abandon things as soon as you step off the property. Like it's impossible to have, what do they call it, distant ownership or remote? Yeah, absentee ownership or something.
Absentee, yeah.
I don't agree with that at all, because I do think that if you do not intend to abandon something, then you don't abandon it, because ownership is the union of the intention to own with possession. That's how ownership happens. That's what homesteading is. That's what distinguishes.
You have to mean to own something. Yeah, you can't accidentally own something, right?
Well, that's why you can sell things, is because you give up your intent to keep it under your ownership and you transfer it to someone else. So it's possible to give up it's possible to lose ownership by losing the ingredient of intent to own. Mm-hmm. But the thing is, property rights has an inherently communicative aspect, because just the very notion of consent implies the ability for people to communicate, because you have to communicate whether you grant permission or deny permission for someone to use your resource, right? Or whether you sell it to them or not. So communication is inherent. Language and communication have to be part of the understanding of property rights. We have to presuppose that people can communicate, but language is always contextual, and just like contracts can never cover every specificity, there always has to be gap filler rules, or what we call suppletive provisions or default provisions, or tacit provisions or implicit understandings that fill in the gaps when language is unclear or we're not sure. So, you have things like good faith, the reasonable man standard, things like that. So, So for example, if I loan you my car, I just hand you the keys. Just because of our previous history and customs and traditions in our community, I didn't say I'm giving you the car forever, but I didn't say I wasn't. I was silent. So what's the reasonable person going to understand? What was my communication that was not expressly stated? We have to make some assumptions about language and people's interactions with each other. And we would say, no, I'm just loaning it to you temporarily, and you have to give it back to me when I ask for it back. If you kiss a girl without her permission, then that's assault and battery. Well, it's battery. But if she gives you permission, it's not assault and battery. So if you're dating a girl and on your fifth date, you've kissed her every time you walk her to her door, and on the fifth date, you walk her to her door and you give her a kiss, you can assume that she consents because she consented the last 4 times and she didn't say anything different, right? So context matters, and interpretation of unwritten sort of communication matters. And I think that plays into the abandonment issue. So if I have a farm and I explicitly abandon it, I tell everyone in town, I'm leaving town, I don't want this thing anymore, it's unowned. Okay, I've abandoned it by making my intentions expressly clear, right? You with me so far?
Yeah, I am. Yep.
So, but what if I leave town and no one knows where I've gone, and it's 30 years later and it's growing up with weeds and no one even knows if I'm still alive? So at a certain point in time, people are going to assume, and what if someone moves in and they start using it and they're there for another generation? They're going to assume that someone who didn't want to abandon it would have come back and kicked the person out, right? That's why the acquisitive prescription usually says you lose your land if someone squats on it and you don't complain for like years, 15 years, 30 years, depends upon on the state or the jurisdiction, because, and that's different than what the mutualists say. Like, so the mutualists say that you abandon it even if you say you're not abandoning it.
Yeah.
All we're doing with the acquisitive prescription assumption is saying, look, we don't know what the guy wanted to do because he didn't say. So we have to make a reasonable guess. Did he really intend to abandon or not? And so the problem is his fault for not being clear. So when someone is not clear, the people left remaining to decide what to do with the property have no choice but to try to make a reasonable guess at what was really meant. So I do think that you could have, I think you can assume abandonment at a certain point. Especially again, if you're like Ted Turner and you have this big ranch in Montana or whatever, and someone builds a farm on the corner of it because they think they said that there's a mistake about the property line. They actually just think they own it and they build it. And Ted Turner doesn't say anything for 30 years. Then you could say that he didn't police his property and he effectively abandoned it in their favor because he had 30 years to make the decision. It's like the abortion thing. Like if you haven't decided to abort by 4 months, okay, you've had enough time, you know. At a certain point.
I don't like the subjectivity that this introduces. I think I will continue defending the no abandonment thing. So I guess it comes down to like
I respect that. That.
So yeah, well, like, you know, in 30 years, when the owner returns to the farm and he says, "Hey, that's my farm, get off," and they go to court. And the court says, okay, well, show me your highest claim to the property, farmer. And he shows, you know, I don't know, the original evidence or deed to the property or whatever. Assume no statist deeds, whatever. And then the squatters, or whatever you want to call them, the people that moved in after the fact, thinking it was abandoned, it would be on them to show proof of abandonment. Like they would have to show a document or, you know, some kind of recording or evidence that the farmer, the original owner, said, okay, I abandoned this property, it's no longer mine. And then they can come in with that proof of abandonment. Otherwise they don't have the highest claim to the property, right?
Well, you know, maybe the customary rules in that community would be, if you can't find the guy and track him down, put a notice in the newspaper and give him a year to respond. And if the guy finally doesn't, I mean, maybe you have to have some duty to try to find the guy, but if he's just if he's not cooperating in the system, and by the way, another way that could solve this, you could have agreements which basically handle these things, like, you know, if I buy land and I have to get a mortgage on it, maybe the bank
like title insurance.
Yeah, it'd be like a title insurance type of thing, which basically it says, okay. And again, when I say communication is essential, let me give another example. Suppose you're in a neighborhood and it's customary for people to walk up to their neighbors' doors and knock on them to ask them for a favor, like, or a question, like, hey, do you know when the garbage comes tomorrow? Or could you loan me a cup of sugar or something like that? Now, when I walk up to my neighbor's house, technically I'm using their property. So is it trespass or is it consented to? Now, I would say it's not trespass because there's an implicit understanding that the owner is granting permission because that's commonly done in the neighborhood. So unless I derogate from that by putting up a posted sign and stating the opposite to the normal customary understanding, then I have basically by silence agreed to consent to innocuous uses like that, right? Yeah. Now, you could say something like that is true of the abandonment case. Like if it's understood in a given community, even if you don't personally like this rule, but if this is what the practice that's going on, if everyone says, look, if you don't show up here for 10 years, we're going to declare this to be unowned. Someone's going to move in and you're going to lose it. And if you know that's the rule, then it's kind of on you to rebut that by, every 9 years showing up and visiting or something like that.
As long as he consented to that rule in the first place. But also he could withdraw his consent to that rule. Like it's his property. To encroach upon it in that way would be to reduce his property
you're right.
rights.
You're right. My solution doesn't work.
Sorry.
By the way, you notice I didn't put that in the principles because that's too specific in this. So I didn't put abandonment in there. So that's still up to interpretation. But your argument is arguable. Well, let me ask you this: Do you think that if some Native Americans could show that part of Manhattan was stolen from them, that they should get it back even now?
I could imagine a very specific scenario in which they could show a higher claim to the property, like a specific Native American.
Me too, by the way.
Yeah, and just to clarify for everybody watching, because I get this a lot, like it would need to be like a specific person with a specific claim to a specific section of property.
Correct.
Where they could show non-communal sort of ownership of that, because Native Americans had they didn't. A lot of Native American tribes didn't even have a concept of private ownership of property. They were nomadic and they just kind of roamed around. So that would be insufficient. So it would have to be a very specific situation. But yeah, I think you could conceive of one.
Me too.
Yeah. Okay.
But the reason is because they didn't abandon it. It was basically stolen, right? They were not allowed to make a claim for it all these generations. Maybe a better example would be like the descendants of a slave who was on a plantation. Yeah. And maybe the heirs of the white master still own it. Maybe the black slave's great grandchildren should be able to get that back. I'm not opposed to that kind of stuff at all, as long as you can show a particular enough claim, the right evidence. But the problem is old claims, evidence tends to be lost. Witnesses are all dead.
Yep.
So that's why that's sort of the reasoning behind the statute of limitations, that if you don't assert your rights when they're fresh enough to be able to do justice, if you wait too long, then you've lost your right to.
It can become impossible. Yeah.
It becomes impossible and it becomes unfair to the other side because some of the witnesses they might have needed are now dead and all this kind of stuff. So there's a reason that claims that become too stale or barred, in the common law, this is called laches, LACHES, which is sort of the time equivalent of estoppel, which is another type of equitable defense you can use to prevent someone from making a claim that's unfair for them to make. Again, if you wait too long to assert your rights, then it's just you've lost your right to do it. And that's the logic behind acquisitive prescription, is that if someone's squatting on your property, you have 30 years to kick them out. But if you don't do it, eventually it's too late for you to assert your rights. You've given up your rights. I understand you don't quite agree with it, and it's not something you can prove with deductive reasoning for sure.
You said something really important early on that I want to highlight. You said that it's not these property systems, these rules are not some kind of a priori axiomatic thing that we can extract from the fabric of reality. Property rights are agreements between people. When we talk about having rights to property, we're talking about what rights are, which are reciprocal agreements between people. And so
correct.
You can reciprocate whatever retarded property rights you want amongst people that consent in an area, let's say. But I think what we're arguing for and what we're in search of is the most consistent, the most universalizable, the least rivalrous set of property rules that we can imagine, because that's the whole point.
And they have to be workable and practical, because property is a practical solution to a real problem. And the problem is the problem of conflict. So for the group of people, which is most people, who would prefer to live in a society where we can peacefully trade with each other and deal with each other rather than have physically fighting. So we kind of agree that we need a system of property rights, right? So then the question is, what are they? And that's what I laid out in my plank, is like, those are the rules. And those are the rules that evolved on the private common law anyway, original appropriation and homesteading and rectification for a tort. I mean, that was the core of the Western private law anyway, and the Roman law as well. So like one of the rules has to be self-ownership, because I mean, it doesn't even make sense to say you own real estate or something if you don't own yourself. So that's the core thing. And then you have to be able to use things in the first place for people to survive. So we have to have the ability to go out into the woods and get things that are unowned. Otherwise, we would die. Mm-hmm. So whatever the rules are, they have to permit original appropriation, right? So, and if you believe in property rights at all, part of that is what Hoppe emphasizes. It's called the prior-later distinction, which means it matters who has it first. Because if it doesn't matter who has it first, then there's no property rights, because just because I own something now, someone else can come and take it from me, right? Yes. The very notion of property rights implies that the current user owner has a better claim than someone who comes later. So yes. If you combine that with the idea that we have to be able to use things that are unowned in the first place, combine that with the need for property, and combine that with the prior-later distinction, that means that the first person to use a resource is the owner. So that's original appropriation. And then owning it means you can abandon it. And if you can abandon it, you can give it to someone. That's what this contract comes from: the right to use it and the right to abandon it. And then the security of property rights, meaning you can't trespass against someone's property without their permission, means that if someone does, they have to owe you compensation. So that's the third way. So it all sort of flows from the basic practical need for conflict avoidance mechanisms.
Okay, so we have a person over on Odysee that has just been commenting up a storm. I can't catch up with all your comments. It sounds like you have some fundamental disagreements with myself and Kinsella on the conception of property. You're welcome to hit us up on Twitter. My Twitter is @NotGovernor. Stephan, your Twitter is... What's your Twitter?
NS Kinsella.
NS Kinsella. Sorry, I didn't have that ready. So, send us a tweet, and maybe we can have a back and forth. And if we find that there's some actual meaty disagreements, then we can definitely have the discussion on stream. I have a couple super chats here, but let me make this last call for questions or challenges in the comments. Write question in all caps and give me your question, and we'll get to it. Zeku, thank you for the $5 super chat. He says, woo, freedom. And Phobes donated $5. Thank you for that. He says, no definition of aggression? Makes sense. The LP was run by woke commie redacteds until the Mises crew took over. What are your thoughts? Do you have any thoughts on Mises, the Mises guys?
Me? On the Mises caucus?
Yeah.
Well, I'm a member. I thought it was great. I think, look, I've never been a political activist. I think politics is futile. I still do. But I did join the party about 4 years ago because I just thought I got tired of them not running libertarians and not having a clear libertarian message. I figure if they're going to run, because all my friends think the Libertarian Party is what libertarianism is, right? Mm-hmm. So I just want them to have a consistent libertarian message and good articulate libertarian candidate. That's all. I don't think we're going to win the presidency or anything, but I do want them, and I think it can be a good way to spread our ideas. I mean, a lot of people learn about it from that. So that was my goal, and I do think the Mises Caucus is solid on that. They're Austrian influenced. They're principled. They're anti-war. They're anti-COVID lockdown. So I think it's been a great development.
I agree completely on all counts. I think the LP is, as a political entity, is a big waste of time. It might even be a honeypot that wastes a lot of good, meaning, well-intentioned activists' time. But man, has the messaging been garbage for the last 10 years. And holy shit, has the past few months, now that the Mises has taken over, especially on Twitter, they're on fire. And finally, if nothing else, they're saying the right things to the people that need to hear it. So I'm excited about that. Okay, so we did get a few questions here. Question: when somebody watches the pirated copy and tells their friends that might pay for it, that is free marketing, right?
Yeah, that's one argument a lot of people have made, is that piracy actually often helps the producer. But that's sort of a utilitarian justification, and it's contingent. I mean, I don't think it's not always the case. I do think piracy for music and for movies probably does reduce their sales to some degree. Just like, musicians don't make as much money now as they used to from CD sales. Back in the golden era of CDs, they were making so much money because there was only one business model and it was not easy to duplicate. But now we have streaming and MP3 files that's faded away. That's because of technology and the internet. So business models change over time as technology changes.
All right, next question. If we insert practicality into a non-arbitrary foundation, wouldn't that just be inserting some kind of subjective gobbledygook that promotes conflict rather than reducing it? I guess we're going back to the property. If we insert practicality into non-arbitrary foundation, wouldn't that just be inserting some kind of subjective gobbledygook that promotes conflict rather than reducing it?
I think you can actually make a pretty good, I follow Hans Hermann Hoppe's argumentation ethics. I think that's actually the philosophical way to justify and defend rights. And when I talk about practicality, I'm more describing the system that has emerged and explaining why it emerges. But I do think that you can make actual principled arguments for like the rules that we put in the platform. I think you could defend each one of those as I just did. But just admitting that property solves a practical problem, it just means we have human bodies and we live in a world where there's, we need things to survive. We need scarce resources to act. I don't think that's devolving into consequentialism or utilitarianism or unprincipled thinking.
All right. Last question. If someone without an apparent heir dies, would the property then be up for homestead? I mean, I would say yes. And
yes, although it's those cases are very rare because the law usually has different layers of presumptions of who would inherit. But by the way, under current law, do you know what happens if that happens?
The government taxes a certain percentage of it, right? If there is no apparent heir, yeah. If
there's no heir, then the government gets it. It's called escheat, ESCHEAT. So the government is the backup. In the government's conception, there can be no unowned land. It's impossible to have unowned land in the government's conception.
That's a shady deal.
Yeah. So I would say yes. It's up for grabs as soon as it has no owner, and it has no owner if you die with no heir.
I'll see myself out for that dad joke.
Oh, what was it? Sorry, what was it?
I said that's a sheety deal. You said it's a sheet, and all right. Thank you for
wearing my dad joke shirt right now, which says,
that's bad.
My shirt says, "I like telling dad jokes. Sometimes he laughs."
All right. Mr. Kinsella, as always, it's a pleasure to chat with you. Thanks for coming on today. Is there anything else you'd like to say, or can you direct people to your website?
Just StephanKinsella.com.
There you go. All right. Thanks everybody for watching. Until next time.